.400 people live on Murray Island, or Mer, one of many Torres Strait Islands which Britain annexed to the colony of Queensland in 1879. More than 100 years later, 3 Murray Islanders are fighting a legal battle against the Queensland and Australian governments. They're attempting to prove that islanders are customary owners of land on Mer and sections of the Great Barrier Reef. Their ancestors, they say, have inhabited the island since time immemorial.
This is what would have happened to anyone who tried to take our lands in the early days. They would have had their heads taken off with a bamboo knife, But today we have to use their kind of weapon, so we took them to court.
I'm planted for this court case, all right? You know why I get in there? This area, this land is ours. Our ancestors were living here for many, many, many years before I was born. There was no white people, all right? There was no white people here on Murray Island.
It's my father's land, it's my grandfather's land, my grandmother's land, where I'm related to it, and which also gives me my identity. If I don't fight for it, then I will be moved out of it, and therefore the loss of my identity. And therefore I'm fighting very hard in that case. That's why I became a plaintiff.
If only we can get those people to recognize us, I suppose by saying that the only way that we can prove that the system do exist is to convince the white man's law system to recognize that we have a custom, a tradition, and set of rules that we had to abide by.
Eddie Mabo is the first named plaintiff in the court action which has become known as the Mabo case. Like his fellow plaintiffs, Mabo claims that he and his family, not the state, should have legal title to land on Murray Island. In 1989, the plaintiffs appeared in the Queensland Supreme Court to give evidence in support of their claims.
Just the that this case will be the truth, the whole truth, and nothing but the truth.
You can't fool me. There ain't no Santa Claus.
This is The Law Report, and I'm John Fain. Australian courts don't often see cases litigated for years and years. But in the Queensland Supreme Court this week, a trial commences that's been before the courts since 1982, and looks like going on for quite a while yet. Professor Garth Netheim from the Aboriginal Law Centre at the University of New South Wales in Sydney tells us what it's all about.
Australia stands out as the one major British former colony that has never recognised the pre-existing rights of the Indigenous people. If you take comparable countries like the United States of America or Canada or in New Zealand, there has been recognition of the prior rights of the people. In all of those countries there were treaties negotiated, none in this country, and in those countries the courts have recognised that pre-existing rights can continue. To this date, there has been no such recognition in Australia.
In 1788, the British claimed sovereignty and ownership of the entire Australian mainland, a continent in which Aborigines had dwelt for more than 40,000 years. At the time of colonisation, as many as 500,000 Aborigines lived in distinct tribal areas throughout the land. But to the European mind, they were nomads, without systems of law, social organisation or property rights. So the British could claim the continent without need for treaty or compensation. Legally, it was held to be terra nullius, a land belonging to no one. Murray Island remained unclaimed until 1879, when Britain annexed it to Queensland. By then, the Torres Strait had become a regular shipping and trade route to Europe. To prevent rival colonial powers laying claim to the region, Britain gave control of the Torres Strait Islands to Queensland, again without negotiating treaties. They were proclaimed to be Crown land, but were reserved for the exclusive use of the Melanesian Islanders, who after annexation became British subjects.
A Supreme Court judge has set a time limit of 3 months to complete a trial establishing statements of fact in a long-running court battle over land rights in the Torres Strait.
In May 1989, the Supreme Court of Queensland visited Murray Island to hear evidence in this historic case. The Supreme Court is to determine the facts surrounding the Murray Islanders' claims. The High Court of Australia will then judge their legal validity and whether those claims have any status in Australian law. A High Court decision recognising Islanders' land ownership could set significant legal precedents for similar land claims by Aboriginal people throughout mainland Australia.
As far as the Murray Islanders are concerned, it's very exciting, and we feel that we've made history in terms of the highest court in Queensland coming out to an Aboriginal or an Islander community to sit in our public hall and listen to us.
Silence, all stand please. Yay. All persons having any business before this honourable court in its civil jurisdiction will now draw nigh and give their attendance, and they shall be heard. God save the Queen.
Before we proceed with today's hearing, it's perhaps apposite that I remark that this is an historic occasion. It is the first sittings of the Supreme Court of Queensland on Murray Island. The case is an important one involving, as it does, people of Murray Island pursuing claims against the state of Queensland and the Commonwealth of Australia. Sitting here helps me to understand the evidence concerning Murray Island, its people and its culture. And perhaps most importantly, it enables the people of Murray Island to participate in the process of justice that's being worked out in these proceedings.
We will be attempting to prove to the court that Islanders own particular tracts of land as family groups, with the individual heads having the control over them. And so we've produced a series of maps on the basis of what Koiki and others have told us about where their particular lands are, and they're very clearly defined. One of the interesting aspects of this case is that Islander tradition does very clearly define boundaries, and so we're able to produce a map like this, which shows different people's pieces of land. These are ones which Eddie claims.
The Supreme Court visited Murray Island not only to hear Islanders' evidence, but also to inspect sites of significance to the case. No evidence was taken during this procedure, known as a view, but the sites visited were the subject of much evidence given in the courtroom.
We're at a place called Saurem. This land came to me through my grandmother and her father. And this is the boundary line here. These sort of things that can be seen all over this island. Other families have constructed these things, not just lately, but over many years, to mark their boundaries off from another family. And it's just heaps of rocks. These are small rocks that they've gardened and they picked up and they put them in heaps on the boundary line, like this. And that can be seen all over Murray Island.
That is my boundary, where the mound is. We can see it clear. From there, right along there, this mound over there, right through, is not a straight mound. It's going, curved, and then go right up where my banana garden is. Right through here, this belongs to mine. That mound is not the mounds now we make it. It's from my ancestor. nobody come in here. If they want to come in here, they have to call out for me, and I give them pass to come here. If not, they'll get something. In those days, it was very serious. All right? I chopped the head off. Yeah, just really. I chopped the head off with their gabba gabba. All right? I know my boundaries. I know my lands. I know my areas. I can name them. Where my ancestors will name all the lands. Now white people will give that name to my ancestor about these lands here. I can say this is Damie. That's Damie here. If I take you to another one, I said Duri. This is not white people's name. And if I go to another place, I said Basmet. This is not white people's name. This is Basmet. This is my ancestor's name, native name. And this land belongs to my ancestor, and I'm the heirs. And that land that I want to buy right. I want right for my, I want to get it right. I'm speaking on behalf of all Murray Islanders. We want our right.
Among the facts which islanders are attempting to prove to the court is the existence of a traditional system of land ownership. They must also prove that such a system has survived beyond the island's annexation to Queensland, and that islanders are the rightful inheritors of distinct portions of land which their families have continuously occupied and maintained.
We're both Piadram clansmen. We occupy this area of Lass, and in the past all this area was populated or inhabited by Piadram people, and they've done the same things over the years to protect themselves from the Sager wind, which is the trade wind, of course.
Murray Islanders have an oral tradition of passing on land from one generation to the next. A father tells his son what plots of land he will inherit and points out those land boundaries. But Australian courts disallow hearsay, evidence which is based on what someone else has told you. Instead, they rely on written documents, such as land titles and wills, as proof of ownership and inheritance. However, the plaintiff's lawyers argue that the court must accept traditional oral evidence when determining land ownership because it's the foundation of Miriam culture.
Our lands were given to us by our ancestors. And to us, they are still alive. Their spirit still lives. And to the white man, he's dead, he's finished. To us, we still have a responsibility to them. Now, they've told us that the land is ours. And we know it's ours because they've told us that, and their fathers before them have told them that. It's the same story. No, our legal documents are our ancestors that told us these things.
Mr. Mabo has widened his original statement of claim to include two tiny keys or reefs 10 kilometres east of Mer Island on the northern fringe of the Great Barrier Reef. The Commonwealth is arguing that the keys are submerged and therefore fishing rights cannot be granted because they're in international waters. Evidence will be taken on that subject.
There is a stone fish trap that I'm claiming, and beyond that, there's a bit of map of it. That's the village area, and that's the stone wall, which is a fish trap, and beyond that we have a lagoon that I call Las Keper, and beyond that again is a home reef called Opnor, and then of course there is a stretch of sea which goes out to the Great Barrier Reef, and I claim that because it has special significance as far as our cultural myths and legends go.
Islanders claim that before the arrival of Europeans, they had complex rules of ownership applying to both land and sea. Murray Island families and clans could own seabeds and reefs, even stars, winds and water. Owners had exclusive rights to hunt in their reef areas and fish traps, and intrusion into another clan or family area could result in punishment by death. The plaintiffs in the Murray Island case are now claiming that traditional property rights entitle them to seabeds and reefs which encircle the island, and include their hunting grounds on the northern areas of the Great Barrier Reef. The Commonwealth Government, which is responsible for administration of the high seas and for international fishing treaties, opposes the claim to Australia's territorial waters, and is the second defendant in the Murray Island case.
When the tide, nighttime when the big tide and the tide go out, and the fish got no way to go out, so they end up inside the fish trap, and we always come along nighttime and spare them. They got no way to go out. They always go like the lagoon right on the middle. They always, every fish always go there. Sometimes you just walk along and just pick it up and put it on the basket.
The special sittings have heard evidence of several people in the island village on claims by Eddie Mabo. Mabo wants a ruling which would give him sovereign rights over the land he claims is his. Group that would then pave the way for others on the island to stake a legal claim on their land, which is handed to them traditionally by tribal right.
This is ABC News. It's 8 o'clock.
Mr. Clapham.
The Murray Island case is only the second time in 200 years of European settlement that Indigenous Australians have tried to prove traditional property rights within common law. In 1971, the Yukala people of Gove in the Northern Territory took the Australian government and mining company Nabalco to court. The government had licensed Nabalco to establish a bauxite mine on reserve land which the Yukala claimed to have lived on since time immemorial. Mr. Justice Blackburn delivered a judgment against the Yukala. He acknowledged that the Aboriginal people had their own system of land law, but because they didn't cultivate, buy and sell, or exclude others from their land, they had no form of title which British common law was obliged to recognise. Nabalco soon began mining on the reserve.
In 1970, a Supreme Court judge of the Northern Territory decided that Aboriginal people did not have any customary title to their land, and if they did, they couldn't prove it in any event. We think that he made some errors of history and some errors of law, and we hope that we will be able to overturn the result of that case and establish that traditional rights have come through the act of colonisation, and that all Aboriginal and Islander people in Australia have the right to have their traditional title recognised by the Australian judicial system.
We're going to perform one of our main dance. It's a shark dance. It's about former god Malabomai. He came to Murray Island shores here 300 years ago, and he settled down and made 8 tribes on Murray Island here, where we still keep our traditional tribes here, 8 tribes. This dance we're going to do here is one of the shark clan. We're going to perform it for the judges and the lawyers here today.
Marlow, a Murray Island god, is believed to have arrived on Mur in the form of an octopus to unite the island's 8 clans, which previously worshipped different gods. Islanders say that Marlow gave them laws and religious leaders to govern their lives. They claim that land ownership and cultivation were regulated by Marlow's laws, and that his teachings continue to influence their relationship to the land. It's this claim which has made Marlow worship a central issue in the Murray Island case. Queensland's lawyers argue that no such system of land law or government can be proved, and that Marlow worship ceased to exist when the London Missionary Society converted islanders to Christianity at the end of the 19th century.
God said, "Let us create. Let us make man in our own image." But God was working in the Torres Strait long before the coming of the light. For it is God as we believe, who sent Malo to Murray Island. Who is Malo? Isn't Malo the same as the Indian's Great Spirit? Isn't he the same that the missionaries brought to Murray Island, to the Torres Strait? The statue commemorates the coming of the missionaries to the Torres Strait. The bit here, which is Murray Island, and the octopus represents Malo. The 8 tentacles mean the 8 tribes of Murray Island. What I like about the octopus is it is looking beyond Murray Island, suggests that Malo is universal. In worship, when the mask was worn by the priests, the high priest, the Zogole, it came out in worship with men wearing 2 sharks. And they would jump in front of him like that. And there was a rope behind we call emis, and 2 people behind that would carry that emis. And at the time of initiation, the candidates would lie flat on the ground with their hands outstretched like that, one on top of the other. And Malo would come and stretch his legs 3 times over the candidates. And the idea was that Malo now gave them his blessing so that they become full-fledged warriors.
Let us remember that Christ died for us.
In the Anglican Church, with all its regalias and rituals, ceremonials, my grandfather and others were saying that the Anglican Church is truly the fulfillment of Malo worship.
The Anglican Church was Murray Island's only church until the 1950s. Today, however, the community has 6 different Christian denominations. But the plaintiffs reject the Queensland Government's argument that the arrival of Christianity extinguished belief in Malo. They claim that Malo's teachings continue to affect island life and coexist with the Christian faith.
The Murray Islands have an historical tribal law called Malo's Law, named after the god Malo, who lived among the Murray Islanders many years ago. One villager, Sam Passy, has told the sittings here that the only real Murray Islander is one who follows Malo's law.
One says here, Malo wali aritarit, simaritarit. That means that Malo plants here and there where soil is sufficient, and much of the soil must be used. And that was from the beginning of the time of our ancestors, you know.
People at Murray who wanted a god so that they can find some sort of centrality of government and so on. And therefore Malo came into being. And so Malo forced all these laws that are experiences of every human being, I suppose. That you must not kill unnecessarily, that you must not steal, and all the great truths that come out of that. You take that law, for instance, that Pesurkem eburlem esmalem. Pesur is part of a coconut tree. And the law is that if it falls to the ground, you must let it rot in the ground. And that, of course, feeds the soil, which means that you must not exploit the land. You must let it fertilize again. And as you can understand, it's a natural fertilization, isn't it? And therefore it's good. It's got to be the first-class one, and the best one, because it is God-given. Then you preserve your soil and your land, and you can work on it over and over and over.
It's a yam.
Well, I'm just reading a document. I'm trying to read it in Merriam-Mer, which I'm not very good at, but it's a statement I've heard from many witnesses. Malo tag moki moki, teta moki moki. As I understand it, that means under Malo's law, a man doesn't walk into another man's property and a man doesn't place his hands on other man's property.
It helped establish that there was a traditional system of rules governing the use of land. And we then say that that tradition carries on.
Tag moki. Tag mean hand. Teter mean teter moki. You can go across the village. Our traditional, our culture. Lo blom malo. You must get your permission before you go kiss peace. This one, mean this one. Tag mauki, teter mauki. Adle ged mimika. That mean you can go anywhere lo village. This one lo blom malo.
Isn't the issue in this case that the indigenous people whose laws go back for 40,000 years are saying, why should our law be ignored or overlooked, and your law of 200 years be taken instead?
Once the lands became British, not only did the British Crown, subsequent to the Australian colonies, acquire sovereignty, that is the power to govern, but as part and parcel of the same deal, all the pre-existing rights under pre-existing legal system simply got snuffed out. What the plaintiffs are arguing is that we should recognise legal pluralism, that is, that the pre-existing culture, the pre-existing law, should be recognised and that they can be accommodated in the Australian legal system.
Eddie Mabo claims he's the traditional heir to many blocks of land on Mer Island, which is the main island in the Murray Group. His claim is disputed by some, one of whom gave evidence at this week's hearings. Marwa Dipoma told the court he's lived on his land for 70 years. Land disputes on the island have a long history and are recorded in the island court records, which date back to the start of this century.
And we can go claiming that another family land, not here, this place. No, my uncle place. No claim for this land here, in the bush too, garden place. Only one garden land there, A-U-M, A-U-M. His grandmama share.
The Queensland barristers were quick to seize on these land disputes. 5 of their 9 witnesses were called specifically to challenge Eddie Mabo's claims to particular blocks of land.
These people in here are taking too long, Mr. Dipoma, they're too long.
There are Murray Islanders appearing for the Queensland government, but of course they're not saying that the land belongs to Queensland. They're saying that they are the owners of their plots of land.
Disputes about inheritance and property are inevitable on Mer, a tiny island where people feel an intense connection with land and sea and jealously preserve their boundaries. In 1898, Queensland established an official court of justice on Murray. The island court dealt with both criminal and civil matters, and often heard cases in which neighbours disputed land boundaries or families argued inheritance. Islanders claimed that this court's decisions were guided by Merriam custom and the laws of Marlow. Records of past court hearings are being used in evidence by the Plaintiffs' Counsel to prove that customary land law survived beyond the island's annexation to Queensland.
Napoleon v. Tybee in 1930, land dispute. Napoleon claimant said that he not received his rightful share of land from his father and mother. I claim the following blocks as my portion. Garam, Sabed, etc., etc., and it's signed off George Agnew, Superintendent.
It appears to us that Murray Islanders are probably among some of the most litigious peoples in the world for the quantity of people and the pieces of land that we're dealing with. And they provide a framework of all the rules by which they governed their land ownership. And it's quite unique in Australia, at least to our knowledge, for an Indigenous people to have such intricate rules and also to record them in writing.
I would not wish to leave Murray Island without concluding as I began, and that is by thanking the people of Murray Island and their council for making available the facilities of the island to us in order that we might sit here and particularly to thank them for their hospitality, which they have extended to us during the period of the sittings. Will you adjourn the court, Mr. Barley?
Yea. All persons here present attend the Honourable Court in civil jurisdiction may now depart hence, giving their attendance on Thursday Island at 9:30 Friday morning. That's it.
Dal, could you come over too?
Lovely. Thank you, Kathleen.
No, this is fun. Oh, it's fun. Just to hold it. I thought you were
I'll come round down the
getting excited about it.
The hearing on Murray Island was a short episode in a long ordeal. After 4 days, the court moved back to Brisbane. Anthropologists, writers, historians and public servants gave further evidence for and against the Murray Island plaintiffs. Finally, in September 1989, 7 years after the first writ was filed, Justice Moynihan adjourned the hearings to consider and write his findings. More than a year later, in November 1990, he delivered a 3-volume report to the High Court in Canberra. The judge concluded that Murray Islanders had an enduring relationship to their land that could be characterised as customary land ownership. However, his view of the evidence presented by Eddie Mabo was another matter. The judge discredited much of Mabo's evidence, unless other reliable witnesses corroborated it. Mabo's claims to 36 blocks of land on Muir were denied. Moynihan's findings threatened to sink the Mabo case, now entering its 9th year. In May 1991, the High Court held its final hearing on the Mabo case.
The lawyers arrived here from Melbourne and Perth. Eddie arrived by bus from Brisbane. There was no question other than we all believed we had a just cause and that we would get a reasonable hearing from the High Court.
These 7 judges would consider Justice Moynihan's findings and then determine whether Murray Islanders have a customary right to the land they live on, which Australia's common law should recognise. The judges would take many months to consider and write their judgments. Tragically, in November 1991, the leading plaintiff, Eddie Mabo, was diagnosed with cancer. He was rushed to Brisbane Hospital for radium treatment. The cancer was spreading rapidly. The case he'd led for 10 years was still pending in the High Court. On June 3rd, 1992, only 5 months after Mabo's death, the High Court delivered its historic judgment on the Mabo case.
Ruled that residents of the Murray Islands in the Torres Strait owned customary
Australia
title
has
for their
recognised the legal existence of Aborigines.
This is the most important court decision.
The case is a moral victory, as well as having great significance for land rights.
Victory.
The High Court decided that it didn't need to rule on the validity of Eddie Mabo's claims to particular bits of land on Muir. The real issues it declared were these. Did the community of Murray Island have a system of land ownership which predated white conquest? And if so, was that system still valid? The court answered yes to both questions. Still more controversial was the court's decision that the principles applied in the Mabo case could establish native title on the mainland too. In response, the Australian government in 1993 introduced national native title legislation establishing a specialist tribunal to settle Indigenous land claims throughout Australia.
This is a day of shame for the Australian Parliament.
A day when we recognise that Indigenous Australians had a right to their own soil.
We have 80% of Western Australia can be claimed.
Over 75% of the country.
Its potential to destroy our society.
Leading politicians made some very extreme and unjustifiable statements which seem to have no foundation other than to whip up some anti-Mabo frenzy. It's as if the property elements of this country believed the High Court was there to protect their rights and to deny anyone else's ability to challenge those rights, even if those rights were founded on a legal fiction called terra nullius.
Mabo, 4 letters that have come to stand for a legal revolution. The islanders' victory in the High Court has changed the world in which we live. It has introduced the possibility for reconciliation between black and white Australians. But their victory also reaffirmed one of the strengths of our society. After 200 years of European occupation, our judiciary were able to correct an historical wrong by overturning terra nullius. This is the legacy of Eddie Mabo, his fellow plaintiffs and their tiny island.
Marlowe is not only talking to a Murray Islander, but to the rest of the world. Tag moki moki, teter moki moki. Your hand must not take you to steal what is other people's.